Hello students, I hope that you're all doing fine. This is the 9th lecture of this certification course in which we are going to start with legality of object. So apart from consideration, free consent and capacity to contract, the fourth and the last requirement for the formation of a valid contract is that parties must contract for a lawful object. That is an agreement, the object of which is opposed to the law of the land may be either unlawful or simply void, depending upon the provision of the law to which it is opposed. So there are unlawful agreements, as we noticed that section 23 renders certain considerations and objects as unlawful. So as you can see on the screen, what considerations and objects are lawful and what not, we're going to start with section 23 now. So the consideration or object of an agreement is lawful unless it is forbidden by law, number one, or is of such a nature that if permitted it would defeat the provisions of any law, or is fraudulent, or involves or implies injury to the person or property of another, or the court regards it as immoral or opposed to public policy. Now in each of these cases, the consideration or object of an agreement is said to be unlawful, and every agreement of which the object or consideration is unlawful is void. So section 23 provides a lot of illustrations to clarify the given section itself. So illustration A says that A agrees to sell his house to B for 10,000 rupees. Here B's promise to pay the sum of rupees 10,000 is the consideration for A's promise to sell the house, and A's promise to sell the house is the consideration for B's promise to pay the 10,000 rupees. So these are lawful considerations. But in the illustration B, we notice that A promises to pay B rupees 1,000 at the end of 6 months if C, who owes the sum to B, fails to pay it. Here B promises to grant time to C accordingly. Here the promise of each party is the consideration for the promise of the other party, and they are lawful considerations. The difference between A and B is that of dependency, as we are going to notice later. A promises for a certain sum paid to him by B to make good to B the value of a ship if it is wrecked on a certain voyage. Here A's promise is the consideration for B's payment, and B's payment is the consideration for A's promise, and these are lawful considerations. Now illustration D says that A promises to maintain B's child and B promises to pay A rupees 10,000 yearly for the purpose. Here the promise of each party is the consideration for the promise of the other party, and they are lawful considerations. And in illustration E, we notice that A, B and C enter into an agreement of the division among them of gains acquired or to be acquired by them by fraud. So the agreement is void as its object is unlawful. On that note, I would like to discuss with you students the question which was asked in UPPCSJ examination of 2000, whereby it read that A, C and D enter into an agreement for divisions of gains acquired or to be acquired by them by fraud. A acquired gains by fraud and did not give any share to C and D. Can C and D file a suit against A for division of the gains? So you must relate this given question to the example that I just discussed with you, and hence this agreement is void as its object is unlawful. I'm sure that this gives you the idea of how simple and easy questions can be asked in UPPCSJ examination. Illustration F says that A promises to obtain for B an employment in the public service, and B promises to pay rupees 1,000 to A. The agreement is void as the consideration for it is unlawful. Illustration G says that A, being an agent for a landed proprietor, agrees for money without the knowledge of his principal to obtain for B a lease of land belonging to his principal. Here the agreement between A and B is void as it implies a fraud by concealment by A on his principal. Illustration H says that A promises B to rob a prosecution which he has instituted against B for robbery, and B promises to restore the value of things taken. The agreement is void as its object is unlawful. Now on that note, there is a question which was asked in UPPCSJ examination of 2003 And the question said exactly, once again, exactly the same idea that was mentioned in the illustration. That is, A promises to drop a prosecution which he has instituted against B for robbery, and B promises to restore the value of the thing taken. Is the agreement valid? In the given problem, the agreement is null and void because the object of the agreement is unlawful. Illustration I says that A, the state, is sold for arrears of revenue under the provisions of an act of the legislature by which the defaulter is prohibited from purchasing the estate. B, upon an understanding with A, becomes the purchaser and agrees to convey the estate to A upon receiving from him the price which B has paid. The agreement is void as it renders the transaction in effect a purchase by the defaulter and would so defeat the object of the law. Illustration J says that A, who is B's Mukhtar, promises to exercise his influence as such with B in favor of C, and C to pay rupees 1000 to A. Here the agreement is void because it is immoral. And illustration K says that A agrees to let her daughter to hire to B for concubinage. The agreement again is void because it is immoral, though the letting may not be punishable under the Indian Penal Code. Now, as we begin with section 23, we must understand this question, which again is very simple. It was asked in UPPCJ examination of 2013. It said that unlawful consideration and object have been mentioned under which section of the Indian Contract Act of 1872. So we have options: section 18, section 20, section 26, section 23. So since we have discussed already the section 18 and section 20, I'm pretty sure that you would know that it does not belong to any of these sections. And section 26, as we're going to discuss, is of something else. So the answer is section 23. This again is a very simple question. I'm sure there's no one that couldn't have solved it if only they had gone through the certification course. So we're going to begin our real discussion now. This was just the section and the basic questions related to the same. So as we talk about section 23, students, we have a lot of things in our mind, the very important of which are the two ideas, object and consideration. This section covers the illegality of both the object of the contract and the consideration for it. The object and consideration may in some cases be the same thing, but usually they are different. For example, where money is borrowed for the purpose of the marriage of a minor, the consideration for the contract is the loan and the object, the marriage. So on that note, we're going to discuss a couple of case laws, which again is very important to be cited in the exam. No matter how correct your idea is, if it doesn't have the authority, you would not get marks for it. So on that note, we notice in the case of Chandra Srinivasa Rao versus Korapatti Raja Rama Mohana Rao, that where the court found that the marriage in question was hid by the provisions of the Child Marriage Restraint Act of 1929. The court said that the purpose for which the guardian borrowed the money is to celebrate the marriage of a child, which is an offence under the Act. Thus, the object was to defeat the provisions of the Child Marriage Restraint Act. The court relied upon the earlier decision of the Calcutta High Court in Jafar Meher Ali versus Baj Jute Mills Co., where a debtor transferred certain property to one of his creditors, the object being to give him preference over other creditors, and Justice Saleh stated the difference between object and consideration. He said, the word object in section 23 of the Contract Act was not used in the same sense as consideration, but was used as distinguished from consideration and means purpose or design. If then the purpose of the parties was to defeat the provisions of the bankruptcy law, then there can be no doubt that the transfer would be inoperative under the provisions of section 6 of the Transfer of Property Act. So we're going to start with the idea that forbidden by law, that is mentioned under section 23 in the very beginning of its definition. So where any agreement is forbidden by law, it is clear that it will not qualify the test that is given in section 23. So where the object of an agreement is forbidden by the law, the agreement is void. And as held in Gerulal Parekh versus Mahadev Das, law in this connection means the law for the time being in force in India, and therefore includes Hindu and Mohammedan laws also, and principles of unwritten law. So, a question was asked in UPPCSG of 2012, which said that if object of an agreement is forbidden by law, the agreement is both void as well as illegal, as we just noticed. So, in relation to violation of licenses and permits, cases on this point have mostly been found in agreements involving breach of laws enacted for the protection or promotion of public interest. And in Thithi Pakurdasu versus Bhimudu, the plaintiff was licensed under an excise act to work a liquor shop. Here, the act forbade the sale, transfer or sublease of the license or the creation of a partnership to run the shop. The plaintiff took the defendant into partnership. The partnership was held void, as it would defeat the policy of the law if unapproved persons could find their way into working liquor shops. Much, however, depends upon the object of a particular statute and the object of the agreement as interpreted by the court. So, as held in Babia versus Muhammad Abdul Subhan Khan, if the intention of legislature is to forbid an act in public interest, an agreement to do the forbidden act will obviously be void. But, as observed in Amritsar Rayon and Silk Mills Limited versus Amin Chand Sajde, if the intention is merely to regulate an act by prescribing certain terms and conditions and formalities, a contract to do the act without fulfilling the statutory requirements may not itself be void, even if the parties have to pay a penalty for the breach of the statute. So the case of Bhikanbai versus Hiralal illustrates this point. And in this case, the facts were such that the plaintiff was a lessee of certain tolls under the Bombay Tolls Act 1875, and one of the conditions of the lease was that the lessee should not sublet the tolls to any other person without the permission of the collector. A fine of rupees 200 was payable for a breach of the condition, and the plaintiff contracted with the defendant to sublet the toll to him without obtaining the necessary permission. So the question here was whether the sublease was void or not, and the court held that it was not. The object of the statute, as the court found, was not to forbid such transactions. It was an act passed for the benefit of the revenue and not an act for the protection of public morals. So the transactions may be void as against the collector, but between the parties they stood. Now, in relation to violation of enactments, we notice in the case of SBI versus Aditya Finance and Leasing Co. Limited that where the High Court of Delhi refused to grant specific enforcement of a contract of lease under which a land meant for residential purposes was to be handed over to a bank for commercial purposes in violation of Section 14 of the Delhi Development Act of 1957. And in T.S. Beliraj versus Vinodini Krishna Kutner, a transfer of a minor's property by the guardian without taking a court order was held to be in violation of Section 8 of the Hindu Minority and Guardianship Act. When we talk about assignment of copyright, we notice that the Copyright Act of 1957 permits assignment of copyright in any present or future work. And in the case of Prentice Hall India Limited versus Prentice Hall Incorporated, the statutory permission was held to be not violative of public policy because there are safeguards for the protection of the owner within the framework of the Act itself. Now moving on to the second category as mentioned in the definition of this section, defeat any law. So sometimes the object of or the consideration for an agreement is such that though not directly forbidden by law, it would, if permitted, defeat the provisions of any law, and such an agreement is also void. Easy illustrations are to be found in agreement relating to bail bonds. And in the case of Fateh Singh versus Sanbal Singh, an accused was required under the Criminal Procedure Code to furnish a surety in the sum of 5,000 rupees for his good behavior. He deposited the sum with the defendant and persuaded him to become surety. After the period of suretyship was over, the accused sued the defendant for the amount. Here, the Allahabad High Court held that the agreement was void and the amount irrecoverable. The court said that the intention in requiring a surety is that the surety shall at his own risk see to the appearance of the accused, and this purpose is definitely defeated by an agreement of the above sort. Now, in relation to law of friendly country, We notice that an agreement which defeats the law of a friendly country would be equally void, and an illustration of this is provided with the case law of Raghazzani versus K.C. Sethia, whereby the fact was that the government of India had by regulations made under the Sea Customs Act of 1878 prohibited the export of goods to South Africa. And the plaintiff and the defendant, being aware of the prohibition and in a bid to overcome the embargo, agreed that a larger quantity of jute bags would be shipped from India and made available in Genoa for resale to South African buyers. The defendant here failed to deliver the goods and the plaintiff sued for damages. The Court of Appeal held that while the English courts will not enforce foreign revenue or penal laws, they will not entertain an action based on a transaction which is knowingly intended to involve a breach of such laws. And Learned J. Denning said that if two people knowingly agree together to breach the laws of a friendly country or to procure someone else to break them or to assist in the doing of it, then they cannot ask this court to give its aid to the enforcement of the agreement. In relation to innocent violations, we notice that where the violation of a home or foreign law would not be an affront to public conscience, enforcement may be allowed. And such a possibility was recognized by the Court of Appeal in Harvard versus Schulster Container Transport Limited. Here the facts were such that the owner of an aircraft agreed to pay the plaintiff for successfully removing his aircraft from Nigerian territorial airspace. The plaintiff did so without permission of Nigerian authorities and landed it in Ivory Coast. The plaintiff did so under the belief that there was imminent danger to life in Nigeria, and the Ivory Coast government returned the aircraft to Nigerian authorities. But the plaintiff sued for his fee. Here, students, he was allowed to recover, and the reason was that he had done the job of removing and safe landing, and since his fee was payable on completion of the flight out of Nigeria, he had earned his fee. As for the illegality involved, the court said that although the court would not normally enforce a contract which would enable a plaintiff to benefit from his criminal conduct, since to do so would be an affront to the public conscience, there are circumstances where it would be wrong to disqualify a plaintiff from recovering even though his claim was derived from conduct which constituted a statutory offence. So as we discussed the definition of section 23, the definition of what objects are actually illegal, we must come to this given idea, what is the scope of the term law? So law in this connection means the rules of law for the time being in force in India and includes Hindu and Muslim laws. In the case of Abdul Feroz Khan Nawab versus Hussain B, the Bombay High Court held that according to the Mohammedan law, it is not competent to parties contracting a marriage to enter into a separation deed by which the husband covenanted that his wife might live with her parents. And similarly, Narayan Lakshman Chandwadkar versus Gopal Rao Trimbak Chandwadkar, accepting a son in adoption in consideration of a sum of money was held to be unlawful. So, money and property involved in transactions defeating law is another set of case laws. The Supreme Court considered this part of Section 23 in the case of Surya Saibilini Devi versus Fanindra Mohan Mazumdar. Here the facts were such that the plaintiff, an employee of the Court of Wards, started the business of running a boarding house. The rules of service prohibited him from engaging in any trade or business. The premises were leased nominally in the name of his father-in-law, but the management and finance was the concern of the plaintiff. The business ran for quite a few years. The plaintiff fell ill and had to leave Calcutta for some time. He transferred the business wholly to his father-in-law on the understanding that on his return, the father-in-law would hand back the business and would also account for its profits. But the plaintiff came back and he realized that his father-in-law refused to oblige him. On that note, the plaintiff brought an action to recover back his business, and here the defendant contended that the business was illegal because it defeated the service rules and also the Income Tax Act. So So the Supreme Court here held that the service rules were not statutory and therefore their violation did not render the business illegal. The only question was the evasion of income tax, and on this point, Justice Iyengar found that the law undoubtedly was that where a Benami transaction is entered into for the evasion of taxes, the law would not give its help to either party and would leave them where they are. And in such cases, recovery is possible only if either the illegal purpose has not been carried out or the plaintiff has not to rely upon the illegal transaction. In the context of agreement to evade taxes, we see that in Ram Sevak versus Ramcharan, an agreement between the partners of a firm to conceal income in certain respects so as to evade income tax has been held to be unlawful. Now coming to the third important aspect of this section, that is fraudulent. An agreement made for a fraudulent purpose is void. Where the parties agree to impose a fraud on a third person, their agreement is unlawful. And in the case of Atamal Ramumal versus Deep Chand Kesurmal, where a debtor agreed to pay a separate commission or to give preference to a creditor in order to induce his consent to a composition which is proposed with other creditors, the object of the agreement was held to be fraudulent. And in Ramnath Mishra versus Rajendranath Sanyal, whereby there were two decree holders against the debtor and one of them, the plaintiff, had the debtor's property attached and brought to sale. The plaintiff agreed with the defendant, a prospective buyer, that he would not bid against the defendant and that the defendant would pay him off. The property was thus knocked down to the defendant for a very small price, and it was held that the whole object of the arrangement was fraudulent as it deprived the other decree holder of what he could have got if the sale had been competitive. Accordingly, the plaintiff could not recover anything from the defendant. Now coming to the fourth aspect of this definition, that injurious to person or property. An agreement between two persons to injure the person or property of another is unlawful. And in the same way, if the object of an agreement is such that it involves or implies injury to the person or property of another, the agreement is unlawful and void. In Ram Sarup Bhagat versus Bansi Mandhar, whereby the person borrowed a sum of 100 rupees and executed a bond promising to work for the plaintiff without paying for a period of 2 years, in case of default, the borrower was to pay exorbitant interest on the principal sum at once. The court held that the contract contained in the bond was indistinguishable from slavery, which also involves injury to the person and was therefore void. Now, in Clay versus Yates, an agreement to commit a crime or a civil wrong such as to publish a libel against a person falls in this category. This is what was held in the case of Clay versus Yates. Now, in relation to fruits of crime, we notice that the law does not help a person to recover anything under his own crime. The fruits of a crime are irrecoverable. So, in that context, no person is allowed to benefit from his own crime, and it is on this principle that in Giles versus Giles, a person was not permitted to participate in a succession which he has brought about through murder. And in Beresford versus Royal Insurance Co. Limited, an insured person who committed suicide to enable his representatives to get the insurance money, but they were not allowed to recover. It was held to be an attempt to confer a benefit through his own crime. Now coming to the fifth important aspect of this section, immoral. The law does not allow an agreement tainted with immorality to be enforced. Consequently, every agreement, the object of or consideration for which is immoral is unlawful. And what is immoral depends upon the standards of morality prevailing at a particular time and as approved by the courts. But certain kinds of acts have been regarded as immoral since times immemorial and will perhaps always be so regarded. In connection to immorality, we must discuss a case set whereby interference in marital relations has been an issue. So one such act is interference with marital relations, and in that we have the case law of Bavijli versus Nansar Nagar, where a married woman was given money to enable her to obtain divorce from her husband, the lender promising to marry her subsequently, and it was held that the money could not be recovered. In Fender versus John Mildmay, the House of Lords had to face a difficult case on this point. Here, the defendant, who was a married man at the time, met the plaintiff at a nursing home where she was a nurse. He told her that he was unhappy with his wife and later asked her whether if his wife divorced him, she would marry him after the divorce. She consented and thereupon sexual relations took place between them. The wife petitioned for a divorce on the ground of this adultery and a decree nisi was pronounced. That is not a final decree. A decree nisi was pronounced. The defendant then promised to marry the plaintiff as soon as the decree was made absolute, but he committed breach of this promise by marrying another woman. Here the plaintiff sued him. The claim was resisted on the ground of immorality, but she was held entitled to recover. What is immoral is interference with marital status, whereas in the present case, after decree nisi, the bottom has dropped out of marriage, nothing but a shell is left, and accordingly the circumstances which led to mischief were absent here. Now we realize that dealings with prostitutes have always been regarded as moral. As held in Pierce versus Brooks, if articles are sold or something is hired to a prostitute for the purpose of enabling her to carry on her profession, neither the price of the article sold nor the rent of the thing hired can be recovered. And it has been held in Upfill versus Wright, if a woman takes a house in order to live in it as the mistress of a man and to use it for that purpose, and the landlord at the time when the lease is executed knows that it is taken for that purpose, the landlord cannot recover the rent. In relation to illegal cohabitation, in Beaumont versus Reeves, a promise to pay for past sexual immorality or illegal cohabitation, if under seal, has been held in England to be enforceable. If it is not under seal, it cannot be enforced as past consideration is no consideration. In Dheeraj Kaur versus Bikramjit Singh, the Allahabad High Court allowed a woman to recover arrears of allowance promised to her for past cohabitation. But in a subsequent decision in Alice Mary Hill versus William Clark, the same High Court held that where cohabitation is adulterous, that is to say, where either party is married with a past or future, it will not support a promise. Adultery is not merely immoral, but it is also illegal. In the case of Pyare Mohan versus Narayani, the Rajasthan High Court has put the same thing on a more rational basis. Here, a gift deed was executed by a person in favor of a woman with whom he had adulterous cohabitation. Holding the gift deed to be enforceable, the court said that the word object, as used in section 23, means purpose or design. Past cohabitation, even if adulterous, is no longer the object of the gift. It only supplies a motive. Gift is a transfer without consideration, and hence no question of unlawful consideration can arise. Now students, you must realize that you're coming across a lot of case laws, remembering which is going to take much of your effort and time, and I also realize that the reason why I'm mentioning so many case laws and why I'm mentioning so many categories, subcategories, subtopics under those subcategories is because I want you to holistically prepare the law of contracts for this given examination. And in order to do that, I need you to be at your best. And there may be cases, in fact, I feel that more than 90% of the cases, they will never arise in the given examination. 90% of the cases that you're going to go through, because only 3 questions are asked on an average in PC's examination. Only 3 questions are asked from the law of contracts in the substantive paper, that is law paper 1. However, it is important to be prepared. Once you know about this idea, even if you do not know the exact name of the case law, since there are so many case laws, still having a decent idea about it, you can cite it as an example. So it is important that you understand these concepts. Remembrance can be done for the most important ones. Now, moving on, the 6th and the very important aspect of this given section, public policy. And the rest of our discussion is going to be about this public policy only. So an agreement is unlawful if the court regards it as opposed to public policy. And the normal function of the courts is to enforce contracts, but considerations of public interest may require the courts to depart from their primary function and to refuse to enforce a contract. And in the state of Rajasthan versus Basan Nahata, where a state amendment of the Registration Act of 1908 empowered the registrar to refuse registration of a power of attorney, authorizing the attorney to transfer specified immovable properties because the registration of such documents was opposed to public policy. The court held that the interpretation of the concept of public policy is the function of the court and not that of the executive. So there have been observations in English law about public policy that we're going to discuss first. The circumstances in which a contract is likely to be struck down as one opposed to public policy are fairly well established in England, as held in Jansen versus Dryfontein Consolidated Mines Limited. A contract of marriage brokerage, the creation of a perpetuity, a contract in restraint of trade, a gaining of wage in contract, or the assisting of the king's enemies are all unlawful things on the ground of public policy. And the ordinary function of the courts is to rely on the well-settled heads of public policy and to apply them to varying situations. If the contract in question fits into one or the other of these pigeonholes, it may be declared void, as held in Finder versus John Milne. The courts may, however, mold the well-settled categories of public policy to suit new conditions of a changing world. Now coming to Indian cases adopting English view. The following words of Subba Rao in Gerulal Parekh versus Mahamadeo Das enshrine the present position of the doctrine of public policy in India. The doctrine of public policy may be summarized thus. Public policy or the policy of the law is an elusive concept. It has been described as an untrustworthy guide, variable quality, unruly horse, etc. The primary duty of a court of law is to enforce a promise which the parties have made and to uphold the sanctity of contract which forms the basis of society. But in certain times, the court may relieve them of their duty on a rule founded on what is called the public policy. For want of better words, Lord Atkin describes that something done contrary to public policy is a harmful thing. But the doctrine is extended not only to harmful cases but also to harmful tendencies. This doctrine of public policy is only a branch of common law, and just like any other branch of common law, it is governed by precedents. The principles have been crystallized under different heads, and though it is permissible for courts to expound and apply them to different situations, it should only be invoked in clear and incontestable cases of harm to the public. Though the heads are not closed, and though theoretically it may be permissible to evolve a new head and under exceptional circumstances of a changing world, it is advisable in the interest of stability of society not to make any attempt to discover new heads in these days. So this is what Justice Subba Rao, who was also the Chief Justice of India, had to offer on the given doctrine of public policy. Now in relation to surrender of rights, in the case of Munayammal versus Raja, a wife who is entitled to maintenance can give up her right in consideration of a lump sum payment, but the surrender of the right to claim revision of the amount in the context of rising prices would be opposed to public policy. This is what the court held in this given case. And it has been held in M.K. Usman Koya versus C.S. Santha that an agreement to give up one's legal right is not held by Section 23. The agreement in question here was between the landlord and the tenant. It was entered into during the pendency of eviction proceedings and stipulated that even if an eviction order was passed, the landlord would not evict the tenant. And this was held to be not illegal or against public policy. Further, it has been held in RCC Sales P Limited versus ESI Corporation that the Employees State Insurance Act of 1948 has been enacted for benefit of all the workers covered by it. Its provisions are meant to protect employees from employers. It is a matter of underlying public policy. Such beneficial rights cannot be contracted out either by employers or employees' union. Such contracts are void and unenforceable. Waiver of advantages conferred by law is opposed to public policy. So in relation to payment out of black money, the Delhi High Court has held in the case of Anand Prakash Om Prakash versus Oswal Trading Agency that a contract for the sale of goods whose tenor shows that the price was intended to be paid out of black money is not opposed to public policy and is therefore valid and enforceable. The contract involved transfer of goods and payment of price, and neither is opposed to public policy, and nor can it be said to be designated to hoodwink the revenue. And even if it could be said so, the seller who had delivered the goods could always call for payment out of the innocent money of the buyer. On grabbing of privilege by extraneous influences, a sale of seats in a public institution, example a medical college, is equally opposed to public policy. The Supreme Court in Mohini Jan vs. State of Kerala vs. State of Karnataka has held that the charging of capitation fee in consideration of admission to educational institutions is illegal and impermissible, as it amounts to denial of citizens' right to education and is arbitrary and violative of Article 14 of the Constitution. So a question was asked in UPPCJ 2012, where it said that A promises to obtain for B an employment in the public service, and B promises to pay rupees 1,000 to A. The agreement is, as we can see, going by the trend of these case laws, the agreement was void. And in UPPCJ 2000, a question was asked on the similar lines again, and here you can deduce that from where did question of 2012 arise. It arose from this given question of mains in 2000 of UPPCJ, that A promises to obtain employment for B in the public service and B promises to pay rupees 10,000 to A. Examine the legality of these agreements. Exact same line on which the question was asked. So since the problem here is based on illustration F of section 23, if you would have noticed, which says that the consideration or object of an agreement is unlawful unless, that is section 23 says that the consideration or object of an agreement is unlawful unless it is forbidden by law, or it is of such a nature that if performed it would defeat the provisions of any law, or it is fraudulent, or it involves or implies injury to the person or property of another, or the courts regards it as immoral or opposed to public policy. And in this given case, the agreement is null and void because the consideration of it was unlawful. Now moving on to the subcategory of alienation of land by member of depressed class, we have a case law of Papaya versus State of Karnataka, whereby a portion of land was assigned by the government to a depressed class member in fulfillment of its constitutional obligation under Article 39. Here, the grant was subject to the specific condition that the land would not be alienated. And because of this violation of this condition, and because of the public policy implication, the alienation of the land was held to be of no effect. And lastly, in relation to arbitration award induced by fraud or corruption, we have a case law of Venture Global vs. Satyam Computer Services Limited, where an arbitration award induced by fraud or corruption was held to be against public policy. Now, since we have dealt with public policy, we are going to briefly talk about the heads of public policy. So broadly speaking, there is trading with enemy, and in that we have a case law of Janssen versus Trefontaine Consolidated Mines Limited. Here, it was held that the king's subjects cannot trade with an alien enemy, that is a person owing allegiance to a government at war with the king, without the king's license. Further, in the case of Esposito versus Bowden, the court has held that it is now fully established that the presumed object of war, being as much to cripple the enemy's commerce as to capture his property, a declaration of war imparts a prohibition of commercial intercourse and correspondence with the inhabitants of the enemy's country, and that such intercourse, except with the license of crown, is illegal. Now the second head of this public policy is that of trafficking in public offices. So an agreement by which it is intended to induce a public officer to act corruptly is contrary to public policy. And in the case of Parkinson versus College of Ambulance Limited, for example, an agreement by which a sum of money was provided to a charity on the condition that latter would procure a knighthood for the plaintiff was held void and the money irrecoverable. The third head of public policy is that interference with administration of justice, and in that we have three subheads. So a contract, the object of which is to interfere with the administration of justice, is obviously opposed to public policy. It may take any of the following forms. So the first one is interference with the course of justice, and it has been held in Wind Hill Local Board of Health versus Wind, that any agreement which obstructs the ordinary process of justice is void. In relation to stifling prosecution, which is the second subhead, it is in public interest that criminals should be prosecuted and punished. Hence, in Williams versus Bailey, it was held that an agreement not to prosecute an offender or to withdraw a pending prosecution is void if the offence is of public nature. Such agreements are called agreements to stifle prosecution. You shall not make a trade of a felony. And where a compromise agreement is made before any complaint is filed, it would not amount to stifling prosecution, even if it is implemented after the filing of a complaint which is then withdrawn. And this was pointed out by the Supreme Court in the case of Osef Polo versus Catholic Union Bank Limited. Here, the facts were such that a bank found that the goods in a godown which was pledged to it against a loan were either fraudulently overvalued or withdrawn in collusion with bank officials. The borrowers here agreed to make up for the deficiency by hypothecating more property. Some delay having taken place in the hypothecation, the bank filed a complaint which was withdrawn after the hypothecation was completed. Here, Gajendra Gatkar, Chief Justice, did not agree with the contention that the agreement involved any idea of stifling prosecution. The agreement was entered into before the complaint was filed, and so it would be so unreasonable to suggest merely from the sequence of subsequent events that the documents in question were executed with the object of stifling the criminal prosecution. So, approving cases of this kind in its decision in Union Carbide Corporation versus Union of India, the Supreme Court has pointed out that the distinction between motive and consideration for withdrawing a prosecution is that where dropping of the criminal proceedings is a motive for entering into the agreement and not its consideration, the doctrine of stifling of prosecution is not attractive. Now coming to the third subcategory of this given head of public policy, that is maintenance and shampooing. So explaining maintenance in Neville versus London Express, Lord Haldane has said that it is unlawful for a stranger to render officious by money or otherwise to another person in a suit in which that third person has himself no legal interest for his prosecution or defense. As held in Hartley versus Hartley, shampooing in its essence means a bargain whereby one party is to assist the other in recovering property and is to share in the proceeds of the action. The Madhya Pradesh High Court in Gayabi versus Shri Ram has observed that in India there is no law prohibiting shampooers agreements as that in England. But a number of high courts in India have been of the view that the English principle is applicable. In Harilal Nathalal Taliti versus Bhailal Pranlal Shah, the division bench of the Bombay High Court dealt with an agreement in which a person had agreed to give half share of the property to the financier, valued at Rs 30,000 from such property as he might get whether by a suit or by a private settlement or in any other manner from his father's estate. The court held that the agreement was extortionate and unconscionable and opposed to public policy. In Kathu Jairam Gujjar versus Vishwanath Ganesh Javadekar, an agreement by a client to pay his lawyer according to the result of the case was held to be against public policy. It was said that it is professional misconduct for an advocate to stipulate for or agree with his client to accept as his fee or remuneration a share of the property sued or other matter in litigation upon the successful issue thereof. Now the fourth head of this public policy is that of marriage brokerage contracts. An agreement to procure the marriage of a person in consideration of a sum of money is called marriage brokerage contract, and such agreements are void. A decision of the Orissa High Court in A. Surya Narayan Murthy versus P. Krishna Murthy provides a suitable illustration. Here, the defendant proposed the marriage of his widowed niece to the plaintiff and offered to give her gold and jewels and land. The marriage took place, but the defendant refused to fulfill the rest of his promise. And the court observed that we would like to make it clear at the offset that if gifts or presents to the groom or the bride are made voluntarily, it cannot be attacked as anything immoral or opposed to public policy. But if pecuniary gain is made the consideration of marriage, it is bound to be condemned as reprehensible to all sense of decent morals. In the present case, monetary gain was the sole consideration for the marriage between the two. Now, the last head of public policy, that is unfair, unreasonable or unconscionable dealings with employees. So, where the parties are not economically on equal footing and there is a wide gap in the bargaining power of the parties, where one of them is in a position to exploit and the other is vulnerable, and the contract made with that other is apparently unfair, it can in circumstances be also regarded as opposed to public policy. For example, the Supreme Court laid down in Central Inland Water Transport Corporation versus Brojanath Gangli that a government corporation imposing upon a needy employee a term that can be removed just by 3 months' notice or pay in lieu of notice and without any ground is an exploitation, and every ruthless exploitation is against public policy. Further, the Allahabad High Court distinguished this case in Jagat Bahadur versus District Supply Officer Allahabad, whereby the contract was for the allotment of a fair price shop for distribution of food grains, and it contained a clause for termination of the agreement and withdrawal of the privilege without assigning any reasons. The same was held to be neither opposed to public policy nor violative of Article 14 of the Indian Constitution. A person aspiring for the grant of a fair price shop is perfectly free not to enter into such a contract because he has all the opportunities of the trading in the free food grain market. His position cannot be compared with that of an employee. So students, that sums up this given lecture. In the next 2 lectures, I will continue to discuss this topic, that is legality of object, and then finish the same thoroughly. Thank you.